Judge Liman, presiding over the case, appeared inclined to approve the motions to quash submitted by Brian Freriedman's legal practice. These recent filings by Blake aimed to bolster the contention that Brian Freriedman functions not as legal counsel, but strictly as a PR representative. This strategy proved ineffective because Freriedman is demonstrably defending his clients. Blake's Friday effort to gain leverage failed to influence the judge. Recall the earlier point regarding Wayfair declaring an absence of documents responsive to Blake Lively's demands, specifically requests 1 through 4 concerning payment records or similar materials yielded nothing because such transactions never occurred. That situation, I noted, represented a technical victory for her since Wayfair possessed nothing to surrender. The judge validated this, awarding her that technical win based on Wayfair's lack of producible material while ruling favorably for Wayfair on the remaining matters. He explicitly stated Blake Lively and Ryan Reynolds, whose names appear on all these subpoenas, possess no entitlement to access Brian Freriedman's confidential legal records. The judge remained entirely unmoved by the argument labeling Brian a PR agent rather than an attorney. Deeming the privilege circumventing claim absurd, affirming privilege applies unequivocally. Furthermore, he found Blake's assertion that she wasn't pursuing privileged information unpersuasive and lacking credibility, particularly as she alleges defamation by Wayfair for statements originating from Brian Freriedman. Logically, Wayfair stands as the sole potential source for those statements, yet she hasn't sued Brian Freriedman directly. Consequently, she cannot compel production of engagement letters between Wayfair's legal counsel and any content creators. He acknowledged potential relevance exists concerning whether negative commentary about Lively links back to Wayfair entities and their agent, or whether content creators maintained relationships with Liner and Freriedman and acted under their direction. However, procuring the engagement letters of Liner firm clients is unnecessary to demonstrate this. The specific terms of their engagement with Liner and the nature of their representations lack relevance. Information regarding Liner's connections to content creators is accessible through alternative avenues. Therefore, her allegation that Liner and Freriedman channeled funds to content creators did not sway him. Regarding requests 5 and 6, 5 seeks all documents concerning digital online content creators and influencers, services related to Miss Lively, Mr. Reynolds, any Wayfair defendants, the digital campaign, or the film. 6 demands all documents between you and any journalist, reporter, producer, editor, or media representative concerning the consolidated action, Miss Lively, Mr. Reynolds, or any Wayfair defendants from July 1st onward. It's notable Ryan Reynolds isn't formally a plaintiff, yet his name permeates the proceedings. This is intriguing, especially given my prior discussion about the MNTN IPO. Ryan seemingly deflects blame for the disastrous marketing campaign he orchestrated, which ridiculed MNTN in the film, prompting reactions like, "That's the best you could do, Ryan." His deflection was apparent. An additional insight. This lawsuit reportedly faces skepticism within banking circles, where there's astonishment. Ryan facilitated his wife suing Wayfair for sexual harassment based on a man looking at her. The notion of litigating over someone looking at your wife is apparently an industry joke. Don't be deceived. Insiders recognize Ryan Reynolds orchestrates everything, with Blake merely executing his strategy. They also perceive Ryan doubling down, yet he's viewed as a laughingstock in investment circles, increasingly so in Hollywood. His reputation is damaged. Despite dismissal, revelations about his conduct and cover-up attempts allegedly exposed him as a scam artist. Concerning communications with content creators and journalists, the judge indicated such requests might be reconsidered later if amended lists identified more individuals. However, Lively hasn't currently justified needing these documents from Liner, and the requests risk infringing attorney-client privilege, work product doctrine, and the attorney-client relationship broadly. Documents held by a party's attorney are deemed within the party's control, which doesn't necessitate physical possession, but exists when the party possesses the right, authority, or practical capacity to obtain them. During oral arguments, Liner confirmed it would provide the client file if the Wayfair parties requested it. Liner also affirmed that written communications by Freriedman to content creators or journalists crafted on the Wayfair parties' behalf within the representation scope would be furnished to the Wayfair parties upon request. Therefore, documents responsive to 5 and 6 should largely, if not entirely, be procured via request to the Wayfair parties themselves. Communications with content creators or press about these cases made during representation would presumably be accessible to the Wayfair parties. Should Liner have communicated about this case independently of representing Wayfair, such communications hold minimal relevance to her claims currently. He rejects her framing of him as a PR agent, asserting his communications are undertaken for his client's defense within this litigation. Anything else is irrelevant. A footnote clarifies request 5 specifies Liner needn't produce documents within the Wayfair party's possession or control, only those uniquely retained by Liner. This presents some contradiction, as uniquely retained documents, meaning the Wayfair parties lack copies, would still be under their control if part of the client file. The court interprets the request as not solely targeting Liner's communications independent of its Wayfair representation. Crucially, privilege concerns strongly oppose compelling counsel to disclose documents controlled by Wayfair parties. Asserting privilege belongs to the Wayfair parties themselves in response to direct requests, subpoenas targeting lawyers actively litigating for an opposing party or associated with trial counsel pose significantly higher risks of intruding on attorney-client relationships compared to subpoenas targeting former lawyers or corporate counsel. New York law particularly disfavors subpoenaing active litigation counsel due to client privilege, attorney-client privilege, and work product doctrine. Obtaining information from a former lawyer might be permissible, but privilege protects it here. The court grants Lively permission to issue renewed interrogatories or document requests directly to the Wayfair parties for the communications sought in 5 and 6. Disputes over Wayfair's responses can be raised with the court, allowing the parties to lodge objections. Absent proof, Liner holds uniquely relevant information unobtainable directly from Wayfair parties. Resorting to subpoenas for trial counsel is unwarranted given the adversarial process risks. She retains leave to seek reconsideration later if necessary, though she could have done so regardless. Another footnote mentions, Lively represents she already served an interrogatory requiring Wayfair to identify content creators they contacted. The court previously compelled responses to a similar press-related interrogatory. However, Wayfair's responses might exclude communications made by attorneys on Wayfair 7 and 8. The motion to quash subpoenas 7 and 8 is granted with prejudice. She cannot revive them due to work product doctrine and attorney-client privilege, coupled with their minimal relevance. Attorney-client privilege fosters open communication between attorneys and clients, serving the public interest in lawful justice administration. Federal law shields confidential client-attorney communications intended for legal advice, unless confidentiality lapses. The advice itself becomes an issue. At issue waiver, or privilege is waived. These communications remain absolutely protected. Lively's attempt to circumvent privilege by alleging Freriedman acted as a PR agent failed. The judge affirmed he functions as an attorney in federal court. His client communications protected. Work product doctrine offers qualified protection for documents, tangible things prepared in anticipation of litigation trial by a party or representative, including agents performing investigative analytical tasks. Lively sues for defamation. The judge noted evidence of Freriedman's statements is relevant to her federal state retaliation claims and state defamation claim. Federal privilege law governs. He also highlighted Lively's claim she doesn't seek privileged client conversations. Yet, information Freriedman publicly shares would logically stem from clients during legal advice seeking, absolutely privileged, or discussions with potential witnesses contacted while investigating her complaint allegations, protected work product. Both categories are privileged. Lively suggests requests might uncover public informing communications separate from legal strategy, but the distinction she proposes is vanishingly thin. An interview by Liner probing Lively's allegations' truth would yield material usable both in court defense and public defense. Public statements defending clients are legal defense, not PR. Her PR agent claim is vanishingly thin. She sues the Wayfair parties for defamation, not Freriedman personally. The Wayfair parties' liability hinges on their belief in statement falsity and authorization approval, irrespective of Freriedman's belief basis. The allegedly defamatory statements concern events where Wayfair parties, chiefly Beldoni and Heath, were direct witnesses. They didn't need Liner's witness interviews to assess Freriedman's statement's veracity. They possessed first-hand knowledge. Even if another witness told Liner Lively was truthful and Liner relayed this to Wayfair, it holds minimal probative value regarding the Wayfair party's belief in Lively's truthfulness. Given the information's low relevance and clear privilege work product risks, the requests impose an undue burden and are quashed. Arguments about needing to examine his mental state are countered. Even regarding Freriedman's own state of mind, his client's first-hand knowledge beliefs logically outweigh denials from others. Actual malice allegations were insufficient, where general counsel merely echoed the client's account. Thus, Wayfair's attorney communications remain protected. Blake cannot access them or argue Freriedman acted as a PR agent rather than legal counsel in concert. Blake anticipated this loss, recognizing the request was obscenely overreaching. No judge would breach privilege or disregard his litigation role. The ruling explicitly states Freriedman speaking to the press about her claim's truthfulness constitutes part of his court defense. Instead of accepting this defeat, denying access to communications, she continues attacking Freriedman, filing a second sanctions motion. The first remains pending. Losing the motion to quash, a right they possessed, she retaliates by seeking sanctions against defendant's counsel. She cannot access privileged documents. He defends his clients. She will likely lose under New York Rule of Professional Conduct 3.6 and FRCP 17F. She respectfully requests sanctions against Mr. Freriedman for his relentless media campaign harming her character, credibility, and reputation. This sanctions motion is absolutely ridiculous and unprecedented. It recycles the same arguments and statements from February and March, previously cited as retaliatory in the first sanctions motion. It's baffling they persist. It's identical material concerning him discussing her deposition, potential legal actions beyond decency, avoiding deposition. A 30-minute Billy Bush podcast interview included, "Documents don't lie, people do. I wouldn't want to be on the wrong side of history here." True. February 19th. Her claims were false, filled with unsubstantial hearsay and unnamed persons unwilling to come forward, lacking evidence. Documents do not lie. People do. He defends clients. March 19th, mentioning Ryan Reynolds strangely. Ryan's sanctions motion alleged bullying acceptance alongside false insistence. Reynolds wasn't a key player. His fingerprints are publicly documented all over the smear campaign since day one. True. March 20th, a self-concocted disaster she initiated, a privileged elite twisting law for personal agenda. April 4th, she diverts attention from receipts, actual documents, video footage, and evidence proving no sexual harassment, her own conduct causing organic backlash. She doesn't need discovery to identify smear sources. A mirror suffices. True. He characterized Miss Lively as part of Hollywood elites advancing false claims, blocking court access, weakening the Constitution. True. May 8th. Joked about holding her deposition in Madison Square Garden. TMZ. June 10th. Stated she fears truth, questioned deposition appearance, accused good people of smear campaigns, terrific young man of harassment. Just lawsuit discussion. Miss Kelly opened her podcast implying Freriedman wages war against Blake Lively, believing she's not good, referring to her as a narcissist during a lengthy discussion. He never said narcissist. He discussed her behavior towards reporters, individuals, waitstaff, stating it's unacceptable. Asserting these statements aims to ruin her credibility by suggesting she lies, fears truth, and possesses poor character versus his client's goodness. True. He defends clients, portraying Ballon as a powerful bully's victim. It's defense strategy. This is asinine. Another attempt to secure sanctions via Rule 11 or Rule 3.6, alleging he undermines her credibility. All statements are old. He even takes issue with comments on Ryan Reynolds' SNL jokes about the situation. Freriedman's SNL-related public statements constitute his campaign painting Lively a liar. Correct, she lies about everything. She and Ryan are liars. A hit dog will holler. Guilty parties react defensively. They dislike being called liars. Lively cannot accept organic reactions against her. She persists with sanction attempts, consistently denied by the judge who affirmed Freriedman's right to defend his clients by asserting she lies. No evidence from Freriedman is needed to know she lies. Having now attended her deposition, his prior concern about her dodging it was fair. She rescheduled multiple times. He's entitled to voice those concerns. Blake Lively refuses to accept the court's ruling. Mr. Freriedman possesses the right to speak candidly publicly, answering questions. Concerns about deposition attendance were valid. Now that she attended, Blake demands sanctions. It's a game. This ruling is a win for Wayfair and Freriedman. This sanctions motion is stupid, going nowhere. They won't win it. That's my opinion. Don't miss the next headline. Like, subscribe, and turn on that notification bell. Don't miss the next headline. Like, subscribe, and turn on that notification bell.